Good evening friends. Today I would like to speak about key changes in the assessment procedures under the new budget of 2022. The new budget provides for assessee being able to file updated returns wherever they have filed a return and they would want to change that return, of course subject to payment of additional 25% if the return is revised within 1 year, and up to additional tax and interest of 50% if it is revised beyond a period of 1 year but within a period of 2 years. This is a welcome change, will give opportunity to assessees to do away with litigations wherever they suspect a litigation will continue for longer. Second such amendment is in respect of mandatorily allowing the assessees to have an opportunity of being heard during the assessment proceedings. The faceless provisions did not provide for such opportunity. So, this is again a welcome change. Third welcome change is in respect of avoiding repetitive appeals. So, earlier under section 158 BA, the provisions allowed the assessee to file an application to the concerned officers wherever there were repetitive appeals and possibility to avoid those repetitive appeals where the matters were pending before higher courts. This has been extended to even department. Even department can now, of course with the consent of the assessee, avoid these repetitive appeals, not filing these repetitive appeals wherever a decision of the higher court is pending in earlier years in respect of the same assessee. I would say there are two other changes which I would like to talk about, which are not so welcome changes. First is removal of subsection 9 in 144B, which now gives a handle to the assessing officer to not follow a procedure laid down under the Act, and still the assessment will be deemed to be not non-est. So, essentially the remedy available to the assessees to that extent has been done away with. Second such amendment is postponement of DRP scheme, which was to be brought in under 144C. The last date and was expected by the assessees to bring it by 31st of March 2022 has been extended to 2024. This was the only section which provided for accountability of the revenue authorities and was much talked about. Currently, we are facing litigations across forums, and DRP was being considered as one such forum which could avoid litigation and a finality to the assessment could come. Now, this has been a bone of contention in terms of DRP not following or erring on the side of the revenue. This continues to happen and the accountability has been postponed for another 2 years. Thank you.